Once again, I thought it'd be useful to clarify a point of question that comes up frequently in the comments, often as a disagreement, a debate, and so on. So I want to absolutely clear this up now so that there is no confusion. And this revolves around the length of a blade, which is that to be considered as a folding pocket knife. Now, in my previous video, I talked about this knife here, which is a Spyderco folding pocket knife, which I bought with my own funds and was not a sponsored video. The question was as to the measurement of the blade, because it measures from the hilt here to the very tip of 3 inches. Now, the question that came about is whether the blade is to be measured from the very hilt to the very tip, or whether it is the sharpened portion of the blade. Now, taking this one as an example, let's just say that the base portion here was dull and not sharp. The whole length of the blade from the hilt to the tip is longer than 3 inches. So it would not matter, and it would not be a defense for a defendant to say that this portion here of the blade is dull, but the rest of it is sharp. This would apply whether it is this long or whether it's 5 inches, 6 inches, 7 inches. The logic just doesn't hold up if someone were to say that a small section of it was dull and only the latter portion of it was sharp, and therefore it should be a folding pocket knife within the exemption in section 139 of the Criminal Justice Act, because the overall length of the blade is longer than 3 inches. Now, the confusion comes about for 2 reasons. First of all, in section 139 of the Criminal Justice Act, which I'll put up on screen now, subsection 3 says this section applies to a folding pocket knife if the cutting edge of its blade exceeds 3 inches. Now, from that, many people will take it to mean that the cutting edge is the sharpened portion, whereas the correct legal interpretation would be the cutting edge is the entire edge of that blade, whether that portion is sharpened or not. Indeed, whether any of it is sharpened or not. In the case of Brooker and the Director of Public Prosecutions, judgment for which was given in 2005, referring specifically to paragraph 7 of the judgment, it reads, "For my part, I would accept that a sharp blade or pointed instrument is the paradigm case to which section 139 is directed. However, the words of the statute are, as Mr. Matthew for the Crown submitted, unqualified, any article that has a blade. I do not accept that Lord Justice Buxton was laying down a rule to the effect that only sharp blades are caught. He referred to an article with a blade that falls within the same broad category as a knife or sharply pointed instrument. It is important to have in mind that his first concern was to decide the precise question before him, namely whether a screwdriver was caught by this section. In my judgment, we should create a great mischief if we construed this statute so as to invite argument in case after case as to whether or not the object in question was sharp. And thus the decision of the case had the effect that a butter knife with no handle, no cutting edge or point was capable of being a bladed article within the meaning of the Criminal Justice Act 1988 section 139. So taking this judgment and analysis to a knife which has a blade that exceeds 3 inches but only a portion of it is sharp, the whole blade will be taken into account, and if it exceeds 3 inches, then it cannot be a folding pocket knife for the purposes of the legislation. The second reason giving rise to confusion is that there are a number of websites that do claim that a knife could be overall 4 inches or more, as long as the sharpened portion is 3 inches or less. And this is simply not true for all of the reasons that I've just given. So just because something is written on a website somewhere doesn't make this true, doesn't make it okay. And the main point for you to take away from this video is that if you are found with a blade which exceeds 3 inches and you do not have a good reason, even if part of that blade is dull or all of that blade is dull, even if it folds, if it exceeds 3 inches, whether it folds or not, it cannot be a folding pocket knife for the purposes of the legislation. You will need a good reason, not simply an explanation. You will need to vigorously defend your good reason, against which you will be vigorously cross-examined for the court to determine whether or not it was in fact a good reason. So once again, I hope this helps to clear up the confusion. I do not want anyone to be caught out by misguided information on the internet that tries to tell you that it is okay to carry a folding knife with a blade longer than 3 inches so long as some of it is not sharp. That is simply not true, and it will be for you to prove in court as a defendant. And I humbly suggest such a defense is doomed to fail. So please remember to subscribe and like the video, and thank you for watching.